SJC-12412, Commonwealth v. Jeffrey Wimer.
Mr. St. Lawrence, good morning.
Mr. Chief Justice, Associate Justices, good morning, and may it please the Court. My name is Tim St. Lawrence, and I represent the defendant in this his appeal from the denial of a motion to vacate any portion of his sentence requiring him to register as a sex offender as a special condition of probation. Under General Laws, Chapter 6, Section 178C, a second and subsequent conviction of open and gross lewdness and lascivious behavior requires a person to register as a convicted sex offender. The legislature did not define what it meant by second and subsequent conviction in this statute. And so I would suggest that the court looks to the usual meaning given to that phrase, derived from sources available or known to the legislature, such as its use in other legal contexts.
Do we know the factual? I'm really unclear about the dates and
Sure.
what. I just couldn't find it. But
Okay. Yeah, it should be in. I think I cited it or referenced the judge's.
I have the judge's finding. The judge
Right.
said that the defendant in this case pled guilty to two separate charges stemming from two separate events, which occurred on two separate
Right.
days.
And from what I can glean from the plea colloquy, which is also in the record appendix, is that these occurred roughly a month apart, but they were charged together at the same time in the same complaint, and then they were disposed of together at the same plea colloquy.
So you're basing your argument on the fact that that was done on the same day, basically?
The argument is
Defense may have been on different days, but the disposition of the cases took place at the same time.
That's right. And the argument, I think, is that second and subsequent has become a term of art through centuries of use in the common law and in the statutory law, and it's a term of art for recidivism. So a second and subsequent offense means that the second offense or the second conviction must be for an offense committed after conviction of the first offense. Obviously, that's not the case here, where he's convicted at the same time of both offenses.
But those are usually sentencing enhancement, and this is registration, right?
That's right. And
A little different, right?
it is a little different, but the legislature is presumed to know when it speaks of the definitions that it has given to this term through in this case, really centuries of common law and statutory law. So I would suggest the legislature knew when it used the language second and subsequent, that was a term of art for recidivism, and that meant we're going to allow a person that has been convicted of open and gross lewdness, because as this court has recognized and the legislature recognized, I would suggest to the court, is that on the list of sex offenses, it ranks at or the bottom in seriousness. And this court has said that, so I'm not, and I understand it's still a serious offense.
Meaning because it was a non-contact
It's
offense?
non-contact and there's no threat of physical contact.
But the SORB registration is focused on, sort of repetitive and compulsive behavior, right? And the fact that he's done this twice with a month gap, and his wife or his girlfriend observes him doing this too. I can't remember.
That's right.
So he's done this twice, and at least the SORB feels like that's relevant. That it's a multiple. It's not. They're not so much focused on sentence enhancement as compulsive behavior, right?
Right, but I think that goes a step further, and now we're into classification and the factors that we're going to consider for classification, and certainly that could be something considered for classification if he were convicted of a sex offense. But I would suggest that he has not been convicted of a sex offense. You can also look to the OUI statute, which was enacted in 1994 and actually defined second and subsequent. And it defined it as the defendant is suggesting this court define it in this, in this context. I think that's important because, you know, that's in 1994 and they're enacting this in 1999. So presumably, they have full knowledge of how they've defined this just 5 years ago.
Well, isn't it more important that as part of the 1999 amendments, the term second and subsequent conviction was used again in the context of failure to register as a sex offender, where it was clear that it would have had to be a failure to register after a prior conviction for failure to register? Now, they used it in the same statute.
I agree, that's right.
So you don't need to go to 1994
Sure.
OUI. You can look to simply what this legislature at this time understood second and subsequent to mean, because it used it in a context where it had to mean a conviction for a failure to register after a prior conviction.
Even a stronger argument, thank you, Chief Justice. And another point to be made about this is I do think that, you know, there's not much legislative history that I was able to find, but what I was able to find was in 1996, in the 1996 version, it was just one conviction of open and gross lewdness. And that changed in 1999. And so I was able, through looking at some Senate and House reports and the archives of the State House News, to find that there was certainly a debate about whether people with one conviction of open and gross lewdness should be swept into the Sex Offender Registry Board, the requirement. And there was amendments to strike that offense. Ultimately, I think what happened, it's reasonable to infer that there was a compromise adding this language of a second and subsequent conviction. And I would suggest that the legislature realized that we need to give these people an opportunity to reflect after their first conviction, after they've been punished, and give them the opportunity to reform before we require them to register with the board. I realize this is also a civil statute, and but I would suggest, and this court has on occasion applied the rule of lenity in the case that it finds that the phrase or the language is ambiguous.
So
because
back to the Chief Justice's point, that second and subsequent, was that part of the civil part of the statute or the criminal part of the statute that he just referred to?
That was part of the criminal part of failing to register.
So we do have a distinction here, and this second and subsequent's used in the civil portion, that second and subsequent's used in the criminal portion. Does that matter?
I don't think it matters because it would be, I guess, anomalous to be defining a phrase one way in one section of a statute and then another way in another section of a statute where the legislature is not explicitly defining these things, and then to say, well, it meant this in this section, but it meant something completely different in this other section. I don't think that we can presume.
And both of those were written at the same time, the 99 second and subsequent, and this second and subsequent come in, they're drafted at the same time? I just can't remember.
I believe that, and I can't say for sure, but I believe that they were both drafted in 1999 as a general revision after, this court's decisions had essentially gutted the sex offender law. But getting back to the rule of lenity point, my point being that this court has applied it under this, in interpreting sections of this statute, because if a person fails to register, he is subject to criminal penalties, including up to 5 years in prison for a first offense. And so for that reason, if the court does find that there's ambiguity in this language, I would suggest that it look to the rule of lenity and resolve that ambiguity in favor.
We also look to ambiguity, and we often defer to the agency entitled to interpret the statute. So what do we make of the fact that SORB interprets it the opposite way?
I think there's a couple points to be made on that. Number one, this is not an area that is a technical or in the specialized knowledge of the board. This is a statute that is, I guess my point is there's no need to defer because there's no specialized knowledge in defining or interpreting what second and subsequent means. This is a quintessentially judicial duty. Moreover, I do not believe that the agency was involved in drafting the statute, which is a consideration in how much weight you're going to give to the agency's determination or interpretation.
I think they're created at the same time, right? But does the statute say we should give deference to them too? Is there anything, often the statute says we're going to create an administrative agency and it's entitled to some deference. I just don't know the answer to that.
I'm not sure about the answer to that, but the Commonwealth does point out in its footnote 1 on page 12 that the statute does not provide an opportunity for the legislature to review and approve the regulations, and from which this court might then infer legislative confirmation. So you don't have that here.
Let me ask you on the kind of the bundling of a plea and what we make of that. I know there's Resende, where under the ACC statute, in a series of hand-to-hand, in the ACC statute, of course, is different. It says incidences, and we can get into whether that case is right or wrong. But I have an opinion about that. But are there other cases other than Resende's about a person who pleads guilty to 2 or more offenses on the same date, and whether or not we're going to consider those convictions?
For purposes of enhancing a sentence?
Right.
I don't think that I don't know of a case, because I think the legal understanding of subsequent offenses is that it's a recidivist statute, and that
and they use the word conviction in this statute as opposed to Resende's, where they were incidences.
Right. That's right.
Okay.
So if there's no further questions, I would suggest to the court that the defendant here has not been convicted of an enumerated sex offense under Chapter 6, Section 178C, and therefore the order requiring him to register should be vacated.
Let me ask you one more question. Has he finished his 2 years of probation?
Yes.
So he's finished his term of incarceration and his term of probation.
Right.
So the only thing that remains from his sentence is the sex registration.
That's right.
All right, thank you.
Thank you.
Ms. Von Flattern, good morning.
Good morning, Chief Justice Gantz, members of the court. Cynthia Von Flattern, Assistant District Attorney for the Northwestern District for the Commonwealth. The Commonwealth would ask that this court affirm the decision of the motion judge denying defendant's motion to correct sentence, as the sentence was correct as the statute is interpreted by the Sex Offender Registry Board under the regulation 803-1.03. I would submit that the term second and subsequent is not as clear as my brother would say, in the sense that citing to 9024-1A1, where it's clear if for a person to be convicted for a second charge of operating under the influence, right in the statute it says that there has to have been a previous conviction before the commission of the new offense. And there are other statutes where it is made very clear, other criminal statutes where it is clearly set out that there has to have been a prior conviction before the new offense. The open and gross statute here, Chapter 272, Section 16, does not even call for a second and subsequent penalty. So Chapter 278-11A doesn't apply, where it's clear in court proceedings that a person has to have a bifurcated trial before they are convicted of that subsequent offense. It doesn't exist in the open and gross statute. There are a number of cases, and they are cited in the Commonwealth's brief. One of them is Lowe, and one of them is a Doe versus Sorb, where a defendant has been convicted of what they call a second and subsequent offense, not where he would have been notified and given that there was an enhancement under 278-11A, but where the court goes back and sees that the defendant does have a prior conviction, even in another state. In one state, it was, I believe, Rhode Island. In another state, it was Washington State. And they actually had to look and see if there was a situation whether those statutes were like offenses, like enough to our open and gross statute to qualify to make the defendant be a second and subsequent offender. So I don't think that terminology is particularly clear, and therefore I would submit that Sorb had the authority under Chapter 6-178D to promulgate rules and regulations, and to have a definition placed upon Chapter 6-178C, the definition of second and subsequent.
So it says second and subsequent.
Yes.
What does the and subsequent mean? They
Your
could have
Honor,
said just second, but
yes,
they
and
said second and subsequent.
It says second and subsequent, and I don't know that is particularly clear. In one of the appeals court decisions, they actually refer to it as second or subsequent, but it is second and subsequent
There are
in
other
the statute.
statutes which say second or subsequent. This statute, twice, says second and subsequent, and it says so once in a context in which it has to mean that the offense occurred after a prior conviction, because it comes in the context of failing to register as a sex offender, and it's plain, I think, that meant that you failed to register as a sex offender after you had a prior conviction for failing to register as a sex offender. So why should we infer that the legislature in the same statute meant something different when it used the same term twice?
Well, in the definitions, they unlike other where they cite to the statute and they say second and subsequent, or they say repeat offense, and it goes right to the statute, and there is a more clear definition. Here they just left it the way it is, and so I think it then is. I'm not going to say that it's clear under the definitions. It is somewhat ambiguous, and then you have the regulation to flesh it out. And I would
If it's ambiguous, don't you lose under the rule of lenity, which we have said applies in this context of sex registration?
I don't think so, Your Honor, because we have the regulation, which is not ambiguous, and in which I would submit the SORB has not gone beyond its powers and its duties. I have two cases that can be contrasted, and Maker is one of them, where this court has found, or I'm not sure if it's this court or the appeals court, but has found that SORB went beyond its duties when it decided that an incarcerated level 2 or 3 offender had to go to the police station upon release. That's not in the statute, and it went beyond their rulemaking authority. But here, where they're just interpreting and giving a definition or interpreting the definition of open and gross, I don't think they're going beyond their authority, and I think that considering the statute as a whole and what the legislature is concerned about, as well as SORB, which is one of the things that they're concerned about is repetitive and compulsive conduct, that I think that the definition
When you
is
say
reasonable.
that, but I mean, they could have said second conviction, they could have said second offense, but they didn't.
Yes, but again, we don't.
Or second incident.
They could have said second incident, and in the regulations, the 2004 regs where they talk about repetitive and compulsive, the SORB actually talks about incidents, but then in the later regs they talk about occurrences.
So when you charge an offense, I mean, this the other thing that's sort of strange is it's under the definition of sex offense. So a
Yes,
sex offense is a second and subsequent conviction, which is unusual to be referring to a sex offense as a second and subsequent conviction.
yes.
So when your office charges somebody under a criminal statute where there is, as Judge Kafka noted, some kind of a mandatory or potentially higher penalty for a second and
Yes.
subsequent conviction.
Yes.
How would you, don't you phrase it to say he committed X crime and then you also allege that it's a second and subsequent or second or subsequent, and that therefore is viewed as a charge of second or subsequent?
Yes, that's generally how it's done when there is an enhanced penalty under the statute, and that's required for the defendant to be given due process and notice and so forth. And that's what's interesting about this statute. We don't even, in 272 Section 16, it doesn't even call for an enhanced penalty upon a second
I understand that, but when
subsequent
you are convicted of that crime which you've just described, don't you say, Your Honor, he was convicted of a second and subsequent?
The prosecutor would note that for sentencing, but I don't think under the statute, and that's why it's interesting, those cases where the first conviction was out of state, that it didn't appear that that individual had been convicted of a second and subsequent. I don't know from the record in those
But I guess
cases, but
I'm saying something a little bit, I'm asking something different. You have sex offender, okay, so you have two definitions. Sex offense, which has the unusual feature of referring to an offense in the context of a conviction, and then you have sex offender, which is a person who has been convicted of a sex offense. So you have in this statute a person who has been convicted of a second and subsequent offense becomes a sex offender, correct?
yes.
So,
Well,
and in the parlance of the DA world, when you say he was convicted of a second and subsequent offense, what do you mean?
I have talked to my colleagues about this, and I think that an assistant district attorney always keeping in mind enhanced penalty statutes may indict and have that language in it. But I don't know that it really matters in this case where the statute doesn't call for an enhanced penalty.
I understand that does not call for anything. I'm just trying to figure out what the legislature meant something here, and we're trying to ascertain what the legislature meant. And of course, then you look first to the language that the legislature used, and you rely upon that language. And I guess the
Yes.
question is, when the legislature says you are not a sex offender if you are convicted of one lewd and lascivious.
Yes, although that's changed because it used to be that one did.
Right, but in 1999, they changed
Yes,
it.
yes.
They said, we don't want a sex offender.
Yes.
We don't want someone to be a sex offender.
Yes.
For one prior conviction, for one conviction of lewd and lascivious.
Yes.
We want there to be
Two.
two.
Right.
And then they say you are a sex offender. If you look at the precise language, you are a sex offender if you are convicted of a particular sex offense, which here is defined as a second and subsequent conviction for open and gross lewdness. So you are a sex offender if you are convicted of a second and subsequent conviction.
Right. And then I believe that the interpretation and that the SORB has put on that language in terms of the reg and considering the purpose of the sex offender registration laws, that is reasonable. Because they say that a second conviction can arise from the same offense, but it must be from two offenses, and it doesn't matter if there was an arraignment on the same date.
Well, but I mean, but going back to to DA world, it is only, you would only indict somebody as a second and subsequent when there had been a prior conviction before the offense occurred of a crime. That's what makes somebody a second and subsequent.
Yes, I think that's correct, Your Honor, but again, it goes back to, in this particular case, there's no real definition in as a second and for open and gross as a second and subsequent. So
Well, I mean, we're trying to figure out what the definition, we're trying to figure out what the legislature meant. I mean, I understand the legislature could have said, if you commit two offenses, you are a sex offender. They could have said that, but they use this particular parlance, and we're trying to figure out, and they're limited to it, and the rule of
Yes.
lenity applies to our interpretation of it.
well, and it also goes to, he's not convicted as a second. There is no further punishment for second and subsequent. So there's the criminal piece of this, and then there's the registration piece of this. And so that's why what SORB determines is important. And
Well, but arguably, the registration itself is the enhancement, right?
well, we all recognize that registration is a serious matter, and even though it's not criminal, it does have serious repercussions for an individual. But
Could you, just the chiefs, the question he asked earlier, though, why would they use the same language in two different ways in the same statute? That's what I get hung up on that.
well, that I think is I think the best argument, because when you look at statutory interpretation, you would want to look within the statute first. When I think it's fair to say that sometimes the legislature can refer to something that is like a subsequent offense in a different way. For example, right in the definitions, they talk about repeat offense under certain statutes, and then that goes to that statute.
But you don't really have you don't have an explanation right off the top of your head of how you would rationalize two different meanings for the same language in two different places.
Your Honor, only that one would be relating to the criminal offense, and one is registration, and I think that's a good argument. And again, I think that that goes back to SORB having the expertise and charged with the responsibility of interpreting these definitions to make that regulation. I would just want to point out, with respect to the facts of the case and what the colloquy stated in terms of the facts, and stating that there were two separate acts on two separate days, that would be found at Defendant's Appendix 11. If there are no further questions, the Commonwealth
Just to
will-
be clear, you're not suggesting that the fact that he agreed to it matters?
I think that if this court should find that that the sentence is improper based on the legislation, then I think it needs to go back to the judge, because the plea that was agreed to had in mind that the defendant would have to register.
I understand that, but the problem is he's finished his sentence.
Yes, yes.
I think you'd be right if he had not, but we can't send it back now because his sentence is already completed and you'd have double jeopardy issues.
Right, and it's clear it was as a package, but a number of years have gone by, and we have based it on if this court should find that the sentence is illegal, then then that's where we stand. So,
All right, thank you.
thank you, Chief Justice.